Over the past few years, financial services have been delivered with increased technological intensity and have collectively been referred to as FinTech. This has included the design of disruptive business models and financial products. However, the rapid growth of this sector has also come with regulatory challenges. A key concern that has emerged with regard to FinTech relates to data protection and privacy concerns. This is due to the reliance of FinTech services on the data streams generated by the users. In India, the Information Technology Act of 2011 makes privacy policies mandatory for websites and mobile applications in India. These are document privacy commitments that the companies make to their customers. To understand the privacy commitments made by FinTech companies, researchers at the Center for Internet and Society identified and studied the policies of 48 FinTech companies and found that unless users are specifically looking for the privacy policy, they are less likely to find it. The personal information being collected was neither exhaustively stated nor were the ways in which this information was being collected. Companies equate withdrawal of consent with service termination. The choice to withdraw consent for certain types of data processing is usually unavailable. Grievance redressal processes were unclear. A dedicated grievance officer was not appointed. Commitments to time-bound resolution of user queries were absent as well. Companies retain the right to store data for extended periods of time with ambiguously phrased purposes such as enhanced service delivery, protection against fraud and security threat, and statistical analysis of user behavior. There is ambiguity regarding what personal information is shared with third parties. It is also unclear who these third parties might be. Finally, while security measures for data transportation and communication are provided, committing to stricter standards was lacking. India ascribes to a notice and choice-based privacy enforcement model. This requires companies to notify users of their data collection practices before users avail of the company's services. In practice, however, few users read privacy policies, which are notoriously technical and lengthy to begin with. The placement and formatting of privacy policies is cumbersome as well. Clearly, the current model of privacy and data protection has limitations. Its scope and capabilities need to be strengthened, keeping in mind the complex data systems that FinTech companies heavily rely on.